Hello everyone, welcome to today's lesson, Handling of Labor Disputes. Before we officially begin, let's look at the dispute involving Xiao Wang's cousin Amy. She joined the chemical company on February 22, 2021, signing a 2-year labor contract that included a probation period and specified a salary standard. However, during her employment, the actual wages paid did not meet the standard. So, how should Amy safeguard her rights? Before resolving the issue, let's first understand what a labor dispute is. A labor dispute is a conflict arising from the rights and obligations in an employment relationship between the employee and the employer. Think about it. Who are the parties in Amy's dispute? The parties in a labor dispute are the employee and the employer. In this case, it is Amy and the Chemical Limited Company. It is important to note that labor disputes have several distinct characteristics. First, the parties are specific, with one side being the employer and the other the employee. Second, there exists an employment relationship between the parties. Third, the dispute arises during the period of that employment. Fourth, the dispute inherently concerns labor rights and obligations. For example, conflicts arising from unpaid wages or failure to pay overtime belong to labor disputes. What situations fall within the scope of labor disputes? They include disputes arising when establishing an employment relationship, disputes occurring during termination, dismissal, resignation or separation, disputes regarding working hours, rest and leave, social insurance, benefits, training and labor protection, as well as disputes over wages, work injury medical expenses, economic compensation, and severance pay. Of course, other situations stipulated by laws and regulations are also included. So once a labor dispute arises, how can it be resolved? The primary methods are negotiation, mediation, arbitration, and litigation. First, negotiation. This is a voluntary process where both parties mutually understand and directly discuss a solution. It offers high autonomy and is flexible and efficient. For instance, Amy can communicate effectively with the company's human resources department to demand the full salary. Mediation involves a third party stepping in to facilitate an agreement and resolve the dispute if the parties are unwilling to negotiate, if negotiations fail, or if a reached settlement is not executed. They may apply to mediation organizations at the enterprise, grassroots, or township level. Mediation is relatively professional, but entirely voluntary with no coercion. If negotiations with the company fail, Amy can try mediation. Arbitration is when one applies to the Labor Dispute Arbitration Committee for a decision. The time limit for applying for labor arbitration is 1 year, starting from when the party becomes aware, or should have become aware, of the infringement of their rights. When applying, a written request must be submitted detailing the claim and factual basis. With supporting evidence, legal representation may also be obtained. Compared to negotiation and mediation, arbitration not only possesses professionalism, but also quasi-judicial authority and enforceability. If mediation does not work, Amy can consider arbitration. Litigation is the process of having the case tried in court according to legal procedures. If a party is dissatisfied with the arbitration decision, they may sue in court within 15 days. Litigation is authoritative and stringent but comparatively costly. If Amy is unsatisfied with the arbitration result, she can pursue litigation. These four methods together constitute a complete dispute resolution process. Once a dispute arises, the employee may negotiate and settle directly with the employer. If negotiation fails, the matter moves into mediation, which should be completed within 15 days. If no agreement is reached within 15 days, arbitration should be applied for. Upon entering arbitration, the arbitration panel will first attempt mediation. If mediation fails, a decision will be rendered. After the Labor Dispute Arbitration Committee accepts an application, the case is generally concluded within 45 days. For complex cases, an extension of up to 15 days may be approved for non-final, non-binding decisions. If a party is dissatisfied, they may file a lawsuit in the People's Court within 15 days of receiving the decision. Otherwise, the decision becomes effective. For final decisions, if the employee is dissatisfied, they may sue in the People's Court within 15 days. If the employer is dissatisfied, they may sue in the Intermediate People's Court within 30 days. It should be noted that arbitration is a pre-litigation procedure. Without going through arbitration, the court will not accept the case. Court trials involve two levels of appeal and the final decision. The first instance should be concluded within 6 months. An appeal against the first instance judgment must be filed within 15 days, and the second instance should be concluded within 3 months. Next, let's deepen our understanding of labor dispute resolution methods through a specific case. Please watch this video.
Xing Xin, cousin of Xiao Wang, started working for Nahaika Chemical Company, Limited, on February 22, 2021. On March 4, 2021, both parties signed a written labor contract, stipulating a 2-year term, a 2-month probation period, a monthly basic salary of 8,000 yuan, and a probation salary of 6,400 yuan. On June 5, 2021, Xing Xin submitted a resignation application, and she officially left the company on July 8, 2021. From February to July 2021, Xing Xin's actual monthly salaries were 1,150 yuan, 3,880 yuan, 3,900 yuan, 3,700 yuan, 3,600 yuan, and 1,250 yuan, respectively. Xing Xin demanded the company to pay the arrears and economic compensation of 4,000 yuan.
Manager Liu, after completing the resignation procedures today, I only received 1,250 yuan from the finance department. I worked for 4.5 months, but the company hasn't paid the salary arrears from the previous months.
Xing Xin, the company's sales performance was poor in the first half of the year. So this is the maximum salary we can afford. Besides, you have signed the payslip, which means you agree to the salary reduction.
The labor contract stipulated a monthly basic salary of 8,000 yuan. According to the labor law, the company must pay wages as agreed.
Hello?
Since the company intends to default on my salary, I will file a claim with the Labor Dispute Arbitration Commission for both economic compensation and unpaid wages.
On July 10, 2021, Xing Xin applied to the local Labor Dispute Arbitration Commission, which accepted the case and scheduled a mediation meeting with the company representative the next afternoon. At the mediation meeting, the company representative rejected Xing Xin's claims for wages and economic compensation, so she applied for arbitration. On July 12, 2021, the local Labor Dispute Arbitration Commission announced the arbitration award after deliberation. Nahaika Chemical Company, Limited, shall pay Xinxin economic compensation of 4,000 yuan. Nahaika Chemical Company, Limited, shall pay Xinxin remaining wages of 15,642 yuan, and the award was sent to the company's legal representative. The company appealed to the local People's Court. After trial, the court ruled that the plaintiff, Nahaika Chemical Company, Limited, shall pay the defendant, Xinxin, economic compensation of 4,000 yuan and wages of 15,642 yuan. When a labor dispute occurs, first negotiate with the enterprise to resolve it. If negotiation fails, to the Labor Dispute Mediation Committee of this organization. Grassroots people's mediation organizations established according to law, applying for mediation with organizations established in township streets that have labor dispute mediation functions. If mediation fails, apply to the Labor Dispute Arbitration Commission for arbitration. If dissatisfied with the arbitration, an action can be brought before the People's Court.
Please consider what is the key point of the labor dispute in this case. In fact, it is a dispute over wage payments. Now, please also consider through which methods did Amy resolve this issue. Amy successfully used negotiation, mediation, arbitration, and litigation to ultimately resolve the labor dispute. You may outline the labor dispute resolution process based on the diagram shown in the video. Draw a flowchart of the labor dispute resolution process in accordance with your country's laws and regulations. Through today's lesson, you should have a clear understanding of the meaning, characteristics, and scope of labor disputes, as well as the methods and general procedures for handling them. It is hoped that through today's study, you will gain a deeper understanding of labor dispute resolution and be well prepared for your future professional life. In your future work, if you encounter similar issues, I hope you will use the knowledge acquired today to safeguard your legal rights and ensure a smoother career path. That concludes today's lesson.